Moving your life and your assets from Brazil to the United States in 2026 is a high-stakes financial transaction that forces you to navigate risks far beyond immigration paperwork. The window to act under current rules is closing. By September 30th, 2026, the grandfathering period for the EB-5 visa expires, meaning the minimum investment required to secure a U.S. green card is projected to jump from the current $800,000 baseline. Simultaneously, Brazil's Law 15270 has reinstated a 10% dividend withholding tax on non-residents, effective January 1, 2026. This timeline shows the squeeze you are facing. On the left, the capital cost of U.S. entry is set to rise. On the right, Brazil begins taxing your corporate profits the moment you leave the country. Delaying your U.S. expansion strategy now guarantees you will pay a higher price for your visa while absorbing new taxes on your Brazilian income. This financial pressure exists because there is no income tax treaty between the United States and Brazil. Without treaty protection, moving capital between these two jurisdictions creates a risk of double taxation, as both the IRS and the Receita Federal claim the right to tax the same income. Because of this friction, applying standard U.S. immigration logic to Brazilian wealth structures often triggers requests for evidence or outright rejections from U.S. Citizenship and Immigration Services. Navigating this requires a dual-lens legal approach, ensuring your strategy is compliant with New York law and the Brazilian bar, the OAB, at the same time. This process involves taking Brazilian financial realities, like IRPF returns and corporate structures, and translating them through a dual-lens filter so they emerge as compliant evidence for U.S. adjudicators. Securing your U.S. residency requires a forensic financial translation to prevent double taxation. The EB-5 visa is the passive capital pathway to U.S. residency. It requires a minimum investment of $800,000 at risk into a qualifying U.S. project that creates at least 10 American jobs. This flowchart illustrates the source of funds requirement. The U.S. government requires you to track every dollar backward through 7 years of financial history. Your Brazilian tax returns, real estate sales, and inheritance records must be meticulously mapped out for U.S. authorities. If your documentation survives this review, it provides a direct path to a permanent green card for you, your spouse, and your unmarried children under 21. If you are already in the U.S. on a valid visa, you can file concurrently, allowing you to live and work here while your application is processed. The trade-off is significant. You are locking up your capital for several years while inviting scrutiny from both the IRS and the Receita Federal. The EB-5 offers permanent stability, but it demands financial transparency and capital risk. The L-1A visa serves as an active corporate expansion pathway. This requires opening a U.S. branch of an active, successful Brazilian parent company and transferring yourself as an executive or manager. Because the L-1A is a work visa, it offers rapid speed to entry, bypassing many of the wait times associated with other immigration categories. Once your U.S. operations are established, this visa creates a runway to apply for the EB-1C permanent green card. However, the Brazilian parent company must maintain its operations. If the home office closes, your U.S. subsidiary's visa status ends as well. The L-1A trades personal capital risk for operational pressure. It is designed for active founders, not passive investors. The E-2 investor visa is a workaround strategy, as Brazil does not hold an E-2 treaty with the United States. To use this path, you must leverage a dual citizenship from a treaty nation, such as Italy, Spain, or Germany. Using that European passport, you commit capital to direct and develop an operational U.S. business. This gains you work authorization that can be renewed indefinitely as long as the business remains active, extending to your spouse as well. The trade-off is that you must manage this business daily, and the E-2 provides no direct path to a permanent green card. The E-2 avoids capital lockup of the EB-5, but it does not lead to passive permanent residency. Choosing the right visa is not a matter of preference. It is dictated by your primary asset. This decision tree breaks down the starting points: liquid capital, corporate operations, or an EU passport. If you manage a family office or hold liquid wealth and seek passive, long-term stability, the EB-5 is your pathway. If you are an AFTA's founder ready to scale your Brazilian company into American markets, the L-1A is the appropriate choice. And if you hold an EU passport and want to personally run a hands-on startup, the E-2 is your most efficient route. Selecting a pathway that conflicts with your asset profile wastes years of effort and increases your exposure to tax penalties. Entering the U.S. without accounting for the 10% Brazilian dividend tax and the lack of a tax treaty results in unnecessary financial loss. Protecting cross-border wealth requires a specialized dual-jurisdiction legal architecture. This requires an attorney fluent in both the IRS and the Receita Federal. The stability of your assets during this transition depends on a legal strategy unified across both borders. To get this structure in place, visit thelawshell.com to book a confidential consultation with attorney Norca M. Shell and her dual license team.